In 1984, the United States Supreme Court ruled that a federal agency was entitled to deference for its interpretation of a statute if the agency was exercising authority delegated by Congress. When evaluating an agency action under the so-called Chevron test, the first step is for the court to determine whether the legislative act is clear. If so, that's the end of the matter and the legislation controls. If the statute's ambiguous, then the court will defer to the agency interpretation. In United States v. Mead Corporation, the Supreme Court considered whether Chevron deference would extend to more informal agency decisions. The United States Customs Service issued ruling letters setting tariff classifications for imported goods. Ruling letters represented the official position of the Customs Service and applied prospectively only to goods identical to the ones that were the subject of the ruling. Mead Corporation was in the business of selling day planners and regularly imported these products into the United States. The relevant tariff schedule imposed a 4% tariff on diaries and notebooks, but imposed no import tariff on other miscellaneous items. From 1989 to 1993, Customs treated Mead's day planners as belonging in the category of other items not subject to an import tariff. But in January 1993, Customs headquarters issued a ruling letter classifying the day planners as diaries subject to the 4% tariff. Mead protested the ruling letter. Customs responded by issuing a second headquarters ruling letter with additional explanation about how it reached the conclusion that day planners were diaries. Customs rejected Mead's protest of the second ruling letter. Mead filed suit in the Court of International Trade. In a summary judgment ruling, the Court of International Trade ruled in favor of Customs. Mead appealed. The United States Court of Appeals for the Federal Circuit held that Customs' ruling letters weren't entitled to deference and rejected Customs' reasoning for classifying Mead day planners as diaries. The Supreme Court granted review.